Okay, we're back again with Tom Grieve. You're a former prosecutor and now a defense attorney. And we are deep into the situation of what happens after a self-defense shooting. And in the last couple of episodes, we talked about what goes on right up to the point where you're taken to the police station and maybe you've bonded out or they've released you. What's the legal situation after that? What happens?
Well, you probably don't have your firearm. You may have various bond conditions if you've been bonded out. So if you're out of custody, we're basically trying to figure out what's going to happen next. So I often get calls from folks under these exact circumstances where there's been some sort of self-defense incident. They've gone through some sort of interrogation process. Maybe they've raised their rights, maybe they didn't, but at any rate, they're now out of custody. And I get the call from them, usually on a Sunday, and they say, well, there's been an incident. I'm out of custody. The officer said that I should be okay because, frankly, if they really thought that you murdered someone or that you're likely to murder someone, they're not going to let you out of custody. So I know that just intuitively reading through the system and drawing my own inferences of, okay, something's happened. The officer's obviously made a battlefield decision of we're not going to hold him for custody for court to let the DA make the call. We think that this looks reasonably okay, and we're confident enough that it's okay to let him out of our custody. So I know just right off the bat that this is by no means going to be the worst, least defensible self-defense case that I've ever encountered. I know that we're somewhere probably in gray because almost every case is gray or has shades of gray to it. But I know that this is at least going to be on the good end of the spectrum. And I get the call from them. They say, look, there's been an incident. I invite them to my office. They invariably say, no, I think I'm okay. The officer said that I'm going to be okay. And I always tell them this. I said, look, you are probably going to be getting a call in the next 2 to 6 hours, okay? So it's Sunday, maybe it's Monday morning at this point, but you're gonna be getting a call by Monday afternoon, and they're gonna say that they want you to come back in and give another statement. When that happens, you call me first. And they always say, okay. Every single time I've given someone that talk, they say, yep, I'm not worried about it, no problem. Every single time, Monday morning by 10:30, I get a call saying, yeah, they want me to come in and give another statement. And I always tell them, look, they want you to come in and give another statement, not because you failed to identify who the attacker was or what direction they went in or something like that. They're bringing you in to look at you. That's what they're going to be doing here. And we need to really sit down and talk about this first. You're not going to be giving a statement today because they haven't rested. I've had clients who haven't eaten since the incident. And I talk to them and they just seem, I've never met them before, but you can tell they're just lethargic and out of it. You know, it's Monday afternoon at this point. We're sitting down at my office, and they said, yeah, boy, Tom, I don't know. I guess last time I ate was before the incident. I've had this happen. This is real life. So it's something where my job is I always try to focus on people's health, get them rested, get them fed, make sure that they can de-stress and run some interference with law enforcement before we choose whether or not we're going to be making any kind of statement.
And people need to realize, too, that there might be a time gap in there between when the report goes over to the district attorney and when the district attorney comes back to it. And there's a lot of different elements that fall into that, especially police officers' schedules. Some police officers are working this 2 on, 3 off, 3 on, 2 off. There's agencies that I work with that are 6 on and 6 off. And if the incident happens on day 6, that officer's not coming back to fill out his report until 6 days later. So you might be left hanging for a little while before you hear from somebody.
You might, and it's really going to depend whatever happened. You know, in my experience, it's by no means uncommon that what we call an on-call DA or an on-call prosecutor may be contacted, possibly even from the scene, maybe not from the scene, but from the department, just to kind of give them the quick once-over on the case of, look, here's what we've got. Do you want us to hold them in custody? Not every time, but very often I see this happen. So often you do see a DA, a prosecutor consulted very rapidly and surprisingly early on in the process, and they make a snap decision, obviously relying on the officer's own impressions, opinions, and of the evidence about what should be done. But you're absolutely correct. This is not something that necessarily plays itself out super, super, super fast. Obviously, if they do think that something is incredibly dangerous, if they do think that you just murdered someone, all bets are off, and that officer's coming in on their off day. In fact, they're probably not even leaving the department until they can hammer things out. Consistent with your experience?
Yeah, get the on the big elements, get the first report done, and then make sure if we have to add any addendum or we're doing further follow-up investigation or something like that, we got to make contact with somebody. And typically that's on things that people really want to know what's happened, really bad accidents, really bad incidents, something of that nature. So right on there. But what you're saying is, if you get out of jail, you're doing okay for the start. If they decide to keep you, well, then you're probably going to be expecting.
Yeah, not necessarily, not in every case. Keep in mind, of course, everything varies depending upon local practices. So one particular department in one particular city, the adjoining city next door may have a totally different set of policies and procedures. So we can draw certain inferences of something that might be consistent across the spectrum. But I would say that you're doing well if you're out, but that is by no means saying that you are out of the woods, you're in the clear, or anything of the sort. Far from.
So let's just assume that things are going really poorly for Joe Citizen. Okay. And maybe even they did let you out of jail, but after reading all of the reports, the prosecutor decides, yep, we're filing charges. What happens to Joe Citizen at that point?
Well, if you're still in custody, then you're probably going to be just run through whatever they call intake court. But basically, it's intake court. You'll have your official initial appearance in your criminal case. So they're going to be serving you whatever that particular state, whatever their version of what we would call in Wisconsin a criminal complaint, which alleges whatever particular crimes it is, count 1, count 2, count 3, recklessly endangering safety by use of a dangerous weapon, disorderly conduct, whatever it might be.
This is where you're going to hear and learn the state statutes.
This is where you're going to hear and learn the state statutes, the maximum possible penalties, and you'll probably get a brief recitation of a probable cause statement. In other words, this is not evidence, these are not police reports. This is simply a statement that's typically put together by the prosecutor in order to kind of lay out a little bit of the state's case. But keep in mind, it's not meant to be thorough. It doesn't have to be thorough. It's certainly not to be fair and balanced and to tell both sides of the story. It's there simply to establish probable cause. So who's being charged? Why are they being charged? What happened? Where did it happen? When did it happen? And why are we believing the people that we're believing in here? So don't confuse that for evidence. It's just something it has a particular duty, a particular function to discharge, and it's going to do that.
And at that point, the judge gets to say that he or she feels like, yep, we're gonna move ahead with this. Or if the case is really flimsy, and prosecutors don't bring flimsy cases, I've told this all the time to people, that a DA takes on a case or only does something when he thinks he's going to win. Is that correct? You don't spend a whole lot of time on something that, if the cops don't bring you enough evidence, you're like, no, you don't have me enough evidence. I'm not wasting my time.
Honestly, that's certainly the hope, and I would say that 10 years ago that was a lot more common in my experience. There's a lot of DAs who, there's charging to beyond a reasonable doubt. In other words, I'm not going to charge somebody with a crime unless I am confident that I can prove it beyond a reasonable doubt. In other words, I can get it guilty if this goes to jury trial. There's another school of thought for DAs out there, and I'm by no means endorsing this, but it's basically, look, I'm going to charge to probable cause. I'm going to charge, and I'm going to hit somebody with the most amount of charges possible, and I'm going to basically scare them so that their opportunity cost. In other words, if they want to try to take this to trial, if they lose, it's over for them. In order to build that leverage in pretrial negotiations. Now, this is not what I think we all hope the justice system is about, of some sort of bluff and manipulation strategy, but those prosecutors are definitely out there.
Yeah, I recently got a phone call and a series of emails from a guy in Illinois who, in a large group of people, had an imminent deadly threat, pulled his gun, neutralized the threat, didn't have to fire it, just stopped everything. He got charged with 10 counts of reckless endangerment because there was 10 people in the crowd. And he was facing a lot of time for something like that. So
welcome to my day, folks. Welcome to my day.
Absolutely. So after this court hearing, where do we go from there? What's the next steps?
Well, let's just focus on that court hearing a bit, because one of the common things that I'm always running into as a criminal defense attorney is people always want to talk about whatever happened at the case. They think that initial appearance is going to be some big impassioned plea of innocence. It's not a trial, it's nothing of the sort. In fact, you'll probably say virtually nothing, especially if you have an attorney. You're going to identify that, yep, you are who they claim you are, and yep, that address is correct, and no, I don't have any questions about bail, and that's probably it. In fact, if you try to talk, if you try to go into the facts, the judge may literally yell at you to shut up. So Folks, this is a process, this is a procedure, this is not some sort of trial or anything of the sort. That initial appearance tends to be reasonably dry and formulaic. The only exception might be bail arguments, which is something that can be somewhat colorful from time to time. But on the whole, this is not where you're telling your side of the story. That comes later. It's a hurry up and wait process. The only function for that initial court date is, generally speaking, from state to state, is to formally charge you, to allow you to know the maximum possible penalties, to take a look at the probable cause, to set bail on your case. And again, even if the officers set bail at the police department, the judges generally retain the jurisdiction to review, to raise, to lower bail, to modify bail, you name it. And then to set out the case for whatever the next court appearance might be as well.
Yeah, this is step one, and you're in a long series of steps. You're going to know when you're going to be coming back for the next one.
Right.
And when you do come back, what are we looking at then? And what happens in between those two? What is your attorney doing at that time?
Sure. Well, let's assume that you hired an attorney and they're there with you at the initial appearance. So a lot of this is going to vary depending upon whatever the local state laws are. And I'm not going to go too much into that. Maybe it'd be a great topic for another video as to whether or not you're working on a grand jury system versus a preliminary hearing system or something like that. But just keep in mind that your attorney may not have access to the evidence, the videos, the audio, all that kind of stuff right away, even before that court date, at that court date, or following that court date. We call this the discovery process. The discovery in a criminal case is something where we're talking about the evidence that's being used to prosecute you by the government. So your attorney is going to have to file various paperwork, what we call demands for discovery, and the state's going to have a period of time, a reasonable period of time, in order to produce the documents, the evidence that they have within their possession and control over to your attorney, who then, of course, is going to have to then turn it over to you and begin that process. This whole process, oftentimes in a large case, can take a couple months in order to get that all together. In the meantime, you can anticipate that you may have court dates every 3 weeks, every 6 weeks, something like that. It's going to be reasonably common. But until you and your attorney are in a position to know, okay, here's what we're going to be doing, here's some defenses, here's what the next steps are, the judge is probably, hopefully, going to be giving you some time and some slack to build your legal defense strategy, because it's a big case. If this was a smaller case, they may rush you along, but for a larger case, they're probably going to back off and give you a little bit of space and time to maneuver. An average case in Wisconsin, that's a misdemeanor, so a smaller case, a criminal case, but a smaller criminal case, will typically last between 3 to 7 months. A felony will probably last between, on average, maybe 5 to 10 months or 12 months. If we start talking about significant self-defense felonies, now we're probably pushing 7 months to 14 months or something. Yeah. So don't expect your case to be over and done with. Yes, you do have a right to a speedy trial. No, it doesn't mean what you probably think it means. And yes, it's rarely going to work in your favor every time. So just keep all those factors in mind.
Yeah, you may want to have a speedy trial, because I'm imagining that's a stressful 7 months for a lot of your people. But you need to make sure that all the evidence is in place and everything that your defense attorney can do for you is being done for you in that time frame.
Absolutely, and time generally works to our advantage on the defense. It depends upon what kind of client we have. If we have a client that is going to get themselves into trouble, then no, time is not for us. But generally speaking, we want more time on the defense. It gives us more opportunity to learn more about witnesses, maybe the key state witness who was the bad guy's friend, and the bad guy is claiming to be a victim. Maybe all of a sudden they go out and they get busted doing another burglary, another robbery or something like that. Well, if you did a speedy trial, you may have missed that evidence from being able to come in, or maybe you discover something about their past. Maybe someone steps forward because they blurt out at a bar about the fact that they lied about this whole thing. So generally speaking, the defense attorneys, we generally want a case to go a little bit longer as opposed to shorter. But of course, that's also part of the reason why, among many reasons why a case can actually get expensive.
That's what I was just going to mention. I didn't want to be indelicate, Tom, is that
Sure.
As things stretch out and as attorneys are doing their work,
Right.
People need to remember that you're going to be getting billed for this sort of stuff. While this is happening, these are all what we call billable hours, that this is going to get costly. So let's end it right there, Tom. And next time we come back, maybe we can talk about what happens in the dramatic jury trial and see how that works.
Sounds great, Kevin. Looking forward to it.
Thanks for being here.